Welcome to SCOTUScast, a project of the Federalist Society for Law and Public Policy Studies. Our contributors join us from around the country to bring you expert commentary on U.S. Supreme Court cases as they are argued and decisions are issued. The Federalist Society takes no position on particular legal or public policy issues. All expressions of opinion are those of the speaker. Thank you for joining us for this post-decision episode of SCOTUScast, Terrorism-Related Detention and Civil Rights Edition. I'm your host, Christopher Goffis. On June 19, 2017, the Supreme Court decided Ziglar v. Abbasi, which was consolidated with the cases Ashcroft v. Abbasi and Hasty v. Abbasi. Ziglar v. Abbasi was part of a series of lawsuits brought by Muslim, South Asian, and Arab non-citizens who were detained after the terrorist attacks on September 11, 2001. And treated as of interest in the ensuing government investigation. These plaintiffs contended, among other things, that the conditions of their confinement violated their constitutional rights to due process and equal protection. The defendants included high-level officials in the Department of Justice, such as Attorney General John Ashcroft, FBI Director Robert Mueller, and Immigration and Naturalization Service Commissioner James Ziglar, as well as various detention officials. Some of the parties reached settlements, and the district court eventually dismissed some of the allegations against the DOJ officials for failure to state a claim. The U.S. Court of Appeals for the Second Circuit affirmed the lower court's dismissal of plaintiffs' free exercise claims, but otherwise reversed most of the district court's judgment. Plaintiffs, the Second Circuit held, had adequately pleaded claims for violations of substantive due process, equal protection, the Fourth Amendment, and civil conspiracy, and defendants were not entitled to qualified immunity. Defendants then sought, and the Supreme Court granted, a petition for writ of certiorari. By a vote of 4-2, the Supreme Court reversed in part and vacated and remanded in part the judgment of the Second Circuit. In an opinion by Justice Kennedy, the court held that 1. Limited reach of actions brought under Bivens v. 6 Unknown Federal Narcotics Agents informs the decision whether an implied damages remedy should be recognized in this case. 2. Considering the relevant special factors in this case, a Bivens-type remedy should not be extended to the detention policy claims. The allegations that the executive officials and wardens violated the detainees' due process and equal protection rights by holding them in restrictive conditions of confinement, and the allegation that the wardens violated the Fourth and Fifth Amendments by subjecting the detainees to frequent strip searches, challenging the confinement conditions imposed on the detainees pursuant to the formal policy adopted by the executive officials in the wake of the September 11th attacks. 3. The U.S. Court of Appeals for the Second Circuit erred in allowing the prisoner abuse claim against Warden Dennis Hasty to go forward without conducting the required special factors analysis. And 4. The executive officials and wardens are entitled to qualified immunity with respect to the respondents' civil conspiracy claims. Justice Kennedy delivered the opinion of the court with respects to parts 1, 2, 3, 4A, and 5, in which the Chief Justice and Justices Thomas and Alito joined. Justice Kennedy also delivered an opinion with respect to Part 4B, in which the Chief Justice and Justice Alito joined. Justice Thomas filed an opinion concurring in part and concurring in the judgment. Justice Breyer filed a dissenting opinion, in which Justice Ginsburg joined. Justices Sotomayor, Kagan, and Gorsuch took no part in the consideration or decision of these cases. And now, to discuss the case, we have David B. Rivkin, who is a partner at Baker Hostetler LLP.
It's a very good case. To give you sort of my bottom line, I would call this case basically the death of Bivens. Facts are as follows. This is a long-lasting legal exercise where in the aftermath of 9/11, you had a number of individuals, including numerous legal aliens, who were taken into custody and held on a variety of grounds, some as possible material witnesses, some as possible suspects. They were detained, I would say, somewhere from 3 to 6 or 8 months, eventually released and deported. They filed a lawsuit against 2 categories of federal defendants, senior government officials, which included then Attorney General Ashcroft, then FBI Director Mueller, who subsequently went on to new things, and the name party in a case caption is Ziglar, who I believe was Commissioner of INS, And then you had your typical conditions of confinement lawsuit against various sadistic wardens and assistant wardens. So the case came to the Supreme Court. The basic cause of action is Bivens, which is an old cause of action exercise of federal common law, where the courts are dealing with situations where Congress, where Article 1 has not created a cause of action, has not created a remedy, and the courts have inferred it. So they have lost. Let's leave the issues regarding wardens aside, because quite frankly, it's not that interesting. As far as the senior government officials are concerned, the challenge is lost in the district court. They've done better in the Second Circuit, somewhat surprisingly, since it's not the Ninth Circuit. And then it came to the Supreme Court. You have a Kennedy majority opinion that basically robustly rearticulates why Bivens is a disfavored cause of action. There are really only 3 Bivens cases, all of which date to the 1970s, which are Bivens itself. The second case is Davis versus Passman, that had to do with gender discrimination. And then the last one is Carlson versus Green, that had to do with cruel and unusual punishment clause case, particularly withholding medical care from the inmate. And the court said before that we're not going to extend Bivens to new circumstances, absent some compelling special considerations. And an excellent opinion by Kennedy that goes through first explaining what it means to say new circumstances, new context. It's not enough, by the way, to say, well, this is a violation of Eighth Amendment or this is a violation of a Fourth Amendment. You need to look at the same factual. In order to be in the same place as previous Bivens cases, you have to have substantial similarity in the factual context, which is not the case here, because obviously you have not had any challenges in most 3 cases that I mentioned to the senior government level governmental decision-making involving national security. And then the opinion goes through the analysis of whether or not there are special factors that would come out differently, and there are really none here that would counsel in favor of creating a new Bivens remedy. What I wanted to mention, and I think it's very, very important, is that this opinion echoes the deference that Article 3 owes to 2 political branches in the foreign affairs context, and therefore, at least at the meta-theory level, is something you can link to the court's per curiam opinion in the executive order stay, because Kennedy, in going for a special factors analysis, says that because we're dealing with national security, where the political branches have a dominant sway and judiciary is engaged with considerable hesitation, and they're reluctant to intrude on the executive branch decision making, at least, and that's important, absent specific congressional authorization. So that's a very, very good discussion, and again, reminds me of at least the tenor of a court's opinion in the executive order. So it's really not a whole lot to say here. Again, I would just say that, to me at least, look, one can always try. To me, it presages the end of efforts that you see from time to time to extend Bivens to new circumstances. As far as sort of, if you want to know where the balance of a court is, you basically have a Kennedy delivered opinion in which Roberts, Thomas, and Alito have, well, they're a little bit of variability in terms of which portions they joined, but to say for the sake of his discussion, joined. You have a Bryan and Ginsburg dissent, and the Sotomayor and Kagan and Gorsuch took no part in this. I would guess that if Kagan, Sotomayor, and Gorsuch participated in this, it probably would have been a 5-4 opinion, which again is I have no doubt predicting that Gorsuch would have come out the same way as the majority. I'm somewhat reluctly predicting that Sotomayor would have come out in the same way as Breyer and Ginsburg. My hope would have been that Kagan may have not gone this way, but that's a bit of a stretch.
Thank you for listening to this episode of SCOTUScast. SCOTUScast is a project of the Federalist Society, a not-for-profit educational organization of conservative and libertarian law students, law professors, and lawyers. founded upon the principles that the state exists to preserve freedom, that the separation of governmental powers is central to our Constitution, and that it is emphatically the province and duty of the judiciary to say what the law is, not what it should be. Don't forget to subscribe to our podcast series, including SCOTUScast and Practice Group podcasts, on iTunes or Google Play. For an archive of past podcasts, as well as audio and video of past Federalist Society events, please visit our website at fedsoc.org/multimedia. That's fedsoc.org/multimedia.
This has been a FedSoc audio production.